This is Building Tomorrow, the Society of Construction Law Australia podcast.
On the show, you'll hear real conversations about what matters most to the people behind the scenes who are shaping Australian construction.
From lawyers and contract administrators to engineers, commercial managers, consultants, and all the other experts forging the future of Australian infrastructure today. I'm Bronwyn and Matthew.
I'm BJ Lamsal.
And I'm Jennifer Raphael. Today we are discussing one of the most significant periods of residential building reform in Victoria in decades. The Victorian government is undertaking a broad reset of the state's building system aimed at improving safety, consumer protection, regulatory accountability and public confidence in the construction industry. These reforms are not simply about changing the name of the regulator from the Victorian Building Authority to the Building and Plumbing Commission. They go much further. They include reforms to domestic building insurance, expanded rectification powers, a new developer bond scheme, minimum financial requirements, and a broader legislative framework intended to improve administration and enforcement across the building system. At the centre of this discussion is a deeper question: how does Victoria move from a system that often responds to defects after consumers have already suffered loss to one that prevents defects before they are built into homes and apartments? To explore these issues, I am delighted to be joined by two guests who bring deep expertise from different but complementary perspectives. Bronwyn Weir is the Managing Director of Weir Legal and Consulting. She is one of Australia's leading experts in building regulation and regulatory reform. She co-authored the influential Building Confidence Report with Professor Peter Sheargold, a report commissioned by Australia's building ministers following the Grenfell Tower tragedy, which continues to shape building reform across Australia. She also authored a number of other important reports, including the 2024 report Victorian Building Authority, The Case for Transformation, which was a key catalyst for the current Victorian reforms. I am also joined by Associate Professor Matthew Bell from Melbourne Law School. Matthew is co-director of Studies for Construction Law at Melbourne Law School and teaches construction law in both the JD and Masters programs. Matthew recently wrote an article, Victorians' Building System Objective, Can It Rebuild Confidence and Trust in the Construction Industry?, which examines one of the most important features of the current Victorian reform package, the proposed statutory objective to promote and protect the health and safety of building occupants and the public. Let's jump into the discussion. Bronwyn and Matthew, thank you both for joining us.
Thanks for having us.
Absolutely. Thanks, Jennifer.
So, Bronwyn, I'd like to start with you and with the basic but important question, and that is why these reforms and why now? Victoria has had long-running issues in relation to the residential building sector. From your perspective, what has brought the system to this point?
Well, I think you need a political priority to make the sorts of reforms that have been changed in Victoria. And I think that's come from what happened with combustible cladding. Government invested $600 million in cladding rectification. That's a lot of money coming out of government's purse. And you can imagine that within government, you'd have people saying, well, how did we end up in this situation? How do we prevent it from happening again? And that would have, I think, given the political mandate for these reforms. They've taken a while to come through. I mean, Cladding Safety Victoria was set up in 2019, and here we are 6-7 years later coming to the end of their project, and we're finally seeing some of these quite major reforms that have been a long time coming actually coming into effect on the 1st of July. So I think that's really where it's come from, this recognition that the quality of construction has been poor. We've had a major issue in combustible cladding, which has cost the community millions of dollars. And it's time to do something different and actually try to improve outcomes for consumers and improve the quality of our built environment, particularly where places sleep and live.
Yes, absolutely. Your report as well on the Victorian Building Authority was clearly also a major catalyst for these reforms. And I'm interested in the report and the human dimension that you talk about in that report. So the effect that these issues have on families, on people's savings, their homes, and their well-being as well. What were the most significant failures or weaknesses you observed in that report regarding the regulatory system?
So that's the Case for Transformation report, which was published in November 2024. And we looked at 7 long-running complex complaints at the VBA at the time and looked at how the VBA had responded to it as a regulator. And it was quite disappointing, the outcomes there. Key issues where consumers had brought complaints about defective work to the VBA and been told things like, oh, well, we don't really look at defects, go to VCAT or go to dispute resolution service, and maybe if you've got an issue, bring us your expert reports and maybe we'll look at it, but we don't actually do inspections. And this was met with sort of great frustration from people that felt they weren't getting the help that they ought to get from the regulator. But beyond that, what we found was that the regulator was very narrowly focused. So if an owner brought a problem, they would look at that problem about that particular building practitioner, when in fact chances are that more than one building practitioner had dropped the ball on that site. And so there wasn't sort of a holistic investigation going on. There wasn't a focus on all of the potential issues across the site, the quality of drawings, the role of the building surveyor, the builder's activity, potentially engineer design that was poorly created or executed. And there was no sort of looking at things in a comprehensive way for owners. Some of these owners then would get pushed off and wait many, many months before getting any kinds of response. And then when they did get a response, they were told, you must give us this information within 7 days or we're going to close your complaint, after they'd been sitting there patiently for 12 months waiting for somebody to respond to them. So there was just a very poor engagement with consumers and a very sort of an attitude of the regulator just wanting to close things down as quickly as possible and not really do a comprehensive review or take its responsibilities very seriously.
Yeah, absolutely. And you can imagine in that scenario the frustration and really the harm that some of these consumers went through in terms of their mental well-being and dealing with that sort of situation.
Exactly. And the 7 that we dealt with, they were long-standing complaints, and these owners were traumatised, not just from the response from the VBA, but from their engagement during the building process, or in some cases they'd purchased properties that were defective. So it wasn't just the VBA, it was the whole system that had let them down over many, many months and years, which just created this level of trauma that was really quite sad to watch.
So as part of these reforms, the Building and Plumbing Commission will replace the VBA and bring together regulatory insurance and dispute resolution functions. But I guess one concern that sometimes arises with these kind of institutional reforms is that changing of the name can have an appearance of reform without necessarily changing some of the regulatory behaviour. So I'm interested in us discussing what would count as genuine transformation here. Matthew, do you have a view on what the new commission should do differently from day one?
Thank you. I think Bronwyn's already put your finger on it, as usual. You do, Bron, in that there needs to be, and this wording's been used a lot by Anna Cronin and others, a one-stop shop for consumers. And if we are in fact putting consumers first, as a consumer myself, as we all are from time to time, we expect nowadays to be able to get an answer very quickly. Now, of course, for all the complicated reasons that Bronwyn, you and others have identified, it's not possible to get an answer immediately in relation to something as complex as residential construction. But at least we would know that we're in the system, that somebody is dealing with it, and that we're not just being shunted around in the way that was described in your report. So to my mind, bringing everything within the one, not quite the one building, but at least under one roof, is a very, very good idea. But I think something that you've identified, Bronwyn, is that often there'll be reasons why regulators don't feel able to respond. They might be internally constrained, and they may be constrained by a lack of resources. And one of the things that impressed me, firstly in New South Wales, and I think more recently as an observer here in Victoria, is that there has been a very significant recruitment of experts across the board into the new BPC, and they've been much more on the front foot on social media and otherwise. Again, something I think probably has been learned from David Chandler and his work in New South Wales over the years as Building Commissioner there, to be much more upfront with the community of saying, we are here, we will take responsibility, and the buck stops with us.
So you mentioned there that the one-stop shop aspect of these reforms, sort of playing devil's advocate here, is there a risk that potentially the regulator becomes one that has too many roles, too many expectations, too many responsibilities, and just gets stretched thin?
Yes.
Yeah. I guess governments are always looking at these, how the machinery works, are bigger organisations better or smaller organisations better? The one-stop shop is good in theory, but it's a very, very large regulator now. And so obviously they need the resources and the capability to manage staff of, I think, over 700 now that are sitting in the BPC and potentially still growing. So that's a very big organisation to manage, and you start to have to manage those kinds of issues around internal communication, making sure the left hand's knowing what the right hand's doing, and managing just such an enormous number of people to deliver their various functions.
That's right. And not just add to that, and we are in June of 2026 at the moment, and facing, as we're all very aware of, an election at state level here in Victoria, which by no means a political pundit, but it does seem like there's a few possibilities of what that outcome might be. And it is worthwhile noting that the opposition throughout most of these reforms hasn't necessarily been on board with all of them and has blocked some of them. And most recently, the very large reforms that have gone through, the opposition's basically said that they wanted to have more time to look at them. So all of that speaks to me about these being a very significant intervention. And at the very least, there probably would be a review if there was a change of government. So I only mention that because the entire regulatory system relies upon there being a very well-resourced and proactive regulator. Otherwise, it may be that these things become counterproductive.
Yeah, absolutely. I think that's touching upon potentially some of the criticisms that are out there from the broader community as well about just the breadth of these changes, and some potential criticisms about the consultation process that the government has gone through as well, and the lack of time that has been out there to properly consider just the massive breadth of changes. I'm not sure, I've lost count as to how many acts and regulations and amendments of amending acts that we're up to at the moment, but it is quite a complex change. So I guess from both of your perspective, is there a risk associated with that when we get to the 1st of July, people are still not across what's coming down the pipeline?
Well, it's important to realise that, yes, there's been a number of bills, but the enactment and the commencement of each bill is at different timeframes. So what's happening on the 1st of July are very significant changes in terms of first resort warranty insurance, and the new rectification order powers are the two main things that are happening on the 1st of July. And the BPC has been very, very busy getting ready for those changes, because they're not things that you just switch on overnight. I mean, a whole brand new way that insurance policies work under warranty insurance is an enormous shift. And just that shift to first resort is going to shift the regulator in front of problems rather than sitting at the back in a last resort insurance context where insurance never used to be able to be claimed on until the builder became insolvent, effectively, was what happened 95% of the time. So other changes that are coming down through the reforms since then are things like increased powers for the BPC, the new developer bond scheme, which was supposed to start on 1st July, but now it's being pushed. So I think there is a bit of shuffling and a bit of sort of gradually introducing these changes in terms of them actually taking effect. But it is very hard to sort of for industry to, I guess, get their head around the breadth of changes and the timings for commitment and what does it mean from a practical perspective for different practitioners in the industry as these changes come through.
That's right. And I think I'd just add that, there's such a range of levels of knowledge, and ultimately the hope is that the person who's banging a nail into the wall or deciding what type of concrete to use, or all of these decisions which are made thousands of times a day across the state, that person will be the one who's influenced ultimately by these very complex regulations. And look, I've got sympathy for everybody involved, from the bureaucrats who are drafting and trying to consult on this type of legislation through the politicians trying to get their heads around everything. But it is fair to say that if you've been, and I appreciate that it's quite a small number of people who are every day getting up and reading the Government Gazette or reading the building system review reports and those sorts of things. But if you have been keeping track of them over the last few years, I don't think there's much in the current reforms which are a big surprise. Of course, the devil is always in the detail, but the detail is something, as you say, Bronwyn, which needs to get worked out as we go. So again, it just goes to show, and because we're recording this for the Society of Construction Law Australia, we are very, very lucky to have peak bodies like SOCLA, like the HIA, Master Builders, and many, many others to keep members apprised. But I've got every sympathy for everybody trying to keep track of all these things as well. Now's the time, though, to pay attention.
Absolutely. Yeah, there's some quite significant reforms coming through, and Bronwyn, you touched upon a few of them just before in terms of the changes to the statutory insurance, developer bonds, and the expansion of the rectification powers. And we will talk a little bit about that in a moment. But before we do, wanted to touch upon another aspect of the reforms in terms of the building system objective. Matthew, you recently published a paper which talks about this new objective to promote and protect the health and safety of building occupants and the public. And your paper asks whether this objective can sort of rebuild confidence and trust in the construction industry. For listeners who haven't come across your paper, can you explain a little bit more about this objective and why it matters?
Yeah, and I'll just go back a step from an academic point of view, Jennifer. So when I was doing my PhD through King's College in London around about the turn of the last decade, I was looking very hard at regulatory perspectives and theoretical perspectives largely, but Bronwyn, your paper with Peter Shergold and many others around the world, including the work of Dame Judith Hackett, really informed what I then came up with as a 6-element recipe, as it were, for good regulatory design to protect the health and safety of building occupants. And one of the elements that I thought about in there, which could come through by way of this objective, so it is consistent with it, I think, is this idea that, again, there's this holistic approach and that ultimately the buck does stop with somebody who's got responsibility. Now, that's a very difficult thing when there's so many different people involved, including ourselves as homeowners as well, in everything that goes on in the residential building sphere. But just to explain, if people haven't seen the building system objective, I'd say 2 things. The first is that it is one of the more approachable parts of a 600-page piece of legislation, which is called the Building and Plumbing Administration and Enforcement Act. And the second thing is it's more approachable because it's quite short. So for those of you who want to get out Austlii or otherwise look on the legislation webpage, you'll find it in Section 6 of that new Act. And the guts of it is to say that the objective of the building system is to promote and protect the health and safety of building occupants and the public. And then it goes on to give a whole range of very widely framed examples in relation to that. But ultimately, it comes down to any person who has interaction with that building system, which is very, very widely defined, includes all specific legislation and other things, has to have regard to that building system objective. So that is putting very strongly front and centre that as far as the government is concerned and the broader community, that health and safety of building occupants and the public is something to keep front of mind.
Absolutely. I guess there's a question there as to whether this objective, what it means in practice, whether it's merely symbolic or whether it's going to change how regulators and how the courts also approach building disputes and compliance issues. What are your thoughts on that, Matthew?
So this luckily was something that we were able to discuss at some detail, Bronwyn and Matt and Jess and I at the SOCLA conference in Sydney in May. So, I mean, essentially, any time you've got anything in a piece of legislation, including something like this, which is set up front and centre to be an objective, you would expect that the courts are going to take some notice of it. And in fact, there are other parts of the legislation which talk about that courts are to have regard to it in the interpretation of this legislation. So that's very strongly flagging that it will be taken into account. And what we've seen with similar pieces of legislation around the world is that it does tend to be taken into account if there's an ambiguity, or for that matter, it will often come down to, in the professional environment, whether somebody has done something which is marginal but ultimately is deleterious to health and safety. So it would be particularly interesting if we just wound back the clock, the whole issue about combustible cladding, who knew what and when, and ultimately how this might have been interpreted in the lacrosse case and others in relation to combustible cladding. But what we do know is, I think, going forward, is that this is giving a very strong signal that health and safety is a very, very important part of the equation.
I'm sure it'll be something that lawyers discuss and bring before the courts shortly. Bronwyn, from your perspective in looking at regulatory systems, do these kind of statutory objectives help shift culture, or do you think something more is required than just an objective?
Well, I think they're a relatively new part of regulatory development as far as I know. I mean, there are other examples of this in legislation, but I think it's all been pretty recent that governments have tried to introduce these. They're used as a bit to sort of recalibrate, I suppose. In some senses, you might say, well, look, the courts are always going to look at this anyway. And if you look at the NCC, for example, you'll see that there are objectives around health, safety and amenities. So surely this was implicit anyway. But I don't think it hurts to make it explicit, particularly when you've got a number of practitioners that are basically interpreting legislation every day, even though they're not lawyers. And building surveyors, experts in compliance with the NCC, you've got engineers, builders, everyone trying to work out what am I required to do here, and often doing so in a very highly stressed commercial environment where people are looking for things like value management and so forth, and client service and cost and time pressures, and can easily lose sight of these central objectives. I often have people like building surveyors say, oh, well, the problem is with the NCC, it's so hard to interpret and there's so many ambiguities in it. And I say to them, well, you're never going to get a perfect piece of legislation anywhere, and there's always going to be questions for interpretation. What I think is lacking within the industry is this understanding some of these statutory concepts, like the need to look at the objectives of the legislation, the need to think about public interest and those kinds of things that a court will do. So what I hope is that this system objective is read by all practitioners involved, and that they can anchor their decisions or their interpretations back to this when they're having these conversations with each other, and when they're under these commercial pressures around to decide how to interpret the NCC in a way that is going to go to cost savings or time savings, and whether they need to sort of adjust those interpretation approaches in light of this new provision. So I think they're worth having to see, if they work, and so that people can be readily drawn back to something that's sitting there square in the legislation, rather than talking to them about these sort of more airy-fairy concepts of statutory interpretation, which they may sort of find more difficult to reconcile with their day-to-day pressures and the way that their colleagues and others interpret legislation. Everybody now needs to be brought back to this objective. So I think there's certainly some potential for this to really shift and recalibrate how the participants in the industry perform their functions.
I completely agree with that. And I think you really, in talking about that, Bronwyn, there's so many complex interests involved in every decision. And I guess this is the sort of thing, this building system objective, that you need to do the right thing when nobody's watching. There's that as well. But from a broader health and safety perspective, for many, many years now, the first thing you see when you go onto a building site is, of course, big signs saying we need PPE. So the health and safety of workers on site is vitally important. So the concept is not completely foreign to us in the construction industry. But what this does is to actually put the health and safety of people who often have nothing to do with the project, except that they're going to be living in it or working in it down the track. So they often don't have the ability to protect themselves through contract, and they're often not able to get a look in at all in the decisions that are being made. But everybody on site needs to look to their interests as well.
Definitely. So turning now to one of the biggest changes that is coming into effect on 1st of July that we briefly touched on just before, and that is changes to domestic building insurance. So, Bronwyn, you were talking before about the move towards a first resort insurance model as opposed to a last resort insurance model. Just in case our listeners are perhaps not familiar with that concept, are you able to explain that a little bit further?
Sure. So last resort insurance is what we currently have here in Victoria. And in fact, 6 out of our 8 states have a last resort insurance product that is mandatory to purchase when doing domestic building work. What that means is that the insurance must be commenced if the project is domestic building work and it's worth a certain value, and every jurisdiction has different values. But you can only claim on that policy if the builder dies, disappears or becomes insolvent. Now, about 95% of the time, probably more even, that's insolvency. And so what it means is if you've got a defect in your home, or your home's not being complete as fast as you want it to be, or you move in and you have problems, you can't just go and activate your insurance like you could if you had a car accident, for example. A first resort scheme, which we will have on the 1st of July and which Queensland has had in place now for about 3 decades, is where when there is an issue with your property, you are expected to engage with your builder about it first and try to resolve it. But if you can't, you can come to the BPC and you can essentially lodge a complaint. They can send somebody out to have a look at it, and they can ask the builder to come back and fix it if the BPC agrees that there's a problem. And if the builder won't fix it, then the policy will activate at that point. You don't need to wait for the builder to become insolvent. So it's called first resort. It's probably not first resort, it's probably second resort, because we're still going to try and resolve it through orders and other things. But nevertheless, that's the term that's used in the industry, first resort, as opposed to last resort. So as of 1 July, when mandatory insurance is purchased, which it must be whenever a contract is entered into over $20,000 for domestic building work, then it will be a first resort policy.
Yeah, so it's a significant change from that consumer protection perspective, enabling homeowners to be able to access this insurance without having to go through VCAT or chase the builder first. They can access a policy. From a regulatory reform perspective, how important is this, like incorporating this insurance design in improving consumer protection?
It's a game changer, depending on how well it's implemented.
I guess that's a critical question there, isn't it? Is there a risk that this is going to become too expensive or too difficult to administer?
Yeah, look, a lot of people are saying, how are we going to afford it? There's going to be so many more claims. But what we have to remember is that the claims are going to come a lot earlier in the process rather than many, many years later when a builder's become insolvent, or after many years of litigation and costs being spent on litigation, and only to find the builder becomes insolvent at the end of it, and the legal costs far outweigh the maximum payout on your last resort insurance. So we're talking about getting in front of these issues, so coming in much earlier in the process, so maybe during construction, or if not, in the earlier stages after the home is started to be occupied or the renovation, where these issues can be aired very quickly. An inspector can come out and have a look and arbitrate, I guess, between the owner and the builder as to what the problems are, and then require the builder to go out. I mean, for every builder that we have that is, does poor building work, we also have owners that have unrealistic expectations about what good building work's like. And so the trick for the BPC is going to be marrying that and being seen as credible in these inspections and in these directions that are issued to builders, that they're fair and reasonable. And what we should see over time is that builders will be getting that feedback much earlier. So hopefully on the next project, they won't make that defect again. And there'll be definitely a transition, but done really well over time, this really has an inbuilt educative output for builders to get feedback very early about what the regulator thinks is inappropriate, require them to come back and fix, and hopefully they can do that without their business going under, because it's, again, being called back much earlier. And this should deliver better outcomes for everybody, as well as builders understanding what their obligations are and having the regulator step in early to give that feedback.
So exactly. And I think, the Victorian and other schemes have been regarded as junk insurance for many, many years, not really worth it for anybody. As you say, Bronwyn, any new insurance product or insurance intervention, especially one where you've essentially got the government running it, is going to take a while to bed down, as indeed the new statutory duty of care, as it was back in 2020 when that came out in New South Wales. We all thought the world was going to end. It didn't. The insurance market took a while to adjust, and it has adjusted to that. So again, as with any insurance intervention, it's going to be a much better deal for everybody if in fact there were consistent approaches across the country, and that then allows the international insurance markets and reinsurance markets to catch up with it again and have a better idea of what the market is. But yes, I think it's a long overdue adjustment here in Victoria, at least, to give some meaningful insurance. I think also there are some quite interesting details of it which consumers, as you say, Bronwyn, we've got car insurance or whatever, I think we'll appreciate once we get our heads around it, including a recent amendment which came through, which allows consumers to take out better than the default insurance if we pay a little bit more, which is exactly what we do when it comes to home insurance or car insurance and other things as well. So there's a lot of sensible starting points, I think, with this new insurance as well, but we'll see how it goes.
Yeah, so you mentioned there, Matthew, reforms in New South Wales, the statutory duty of care, which Victoria has not decided to incorporate in these reforms. And I guess the question there is potentially why? Why haven't we decided to adopt for Victoria the approach in New South Wales? Bronwyn, do you have any thoughts on that?
Yeah, they're two very different regulatory mechanisms. New South Wales isn't doing first resort to start with and doesn't appear to have an appetite to, although I'm sure they'll be watching what we're doing down here, and they've got Queensland now above and Victoria now on the same page with this. So I think it was sort of a point in time. Statutory duty of care came in at a time when they were reforming particularly Class 2 apartment sector, and it was one of the tools that they used to give some, I guess, litigation rights or more adequate access to private rights. Victoria hasn't done that, and what we've done down here is to really put a lot of, I guess, pressure and expectation now on the regulator actually participating in these disputes. But also first resort is only for Class 1 and up to 3 stories, whereas statutory duty of care was for all building work. So they're very different. It's hard to sort of compare them as apples and apples and say, well, why has one jurisdiction done this and another one hasn't? They focus on very different activities, and statutory duty of care is very much after the fact, whereas first resort is getting in before. So I think I wouldn't say that Victoria won't introduce statute of duty of care, but they've done a lot of other things instead, including following New South Wales on the developer bond scheme. So I'm not sure why they didn't do it, but I feel like they've done a bunch of other things that are very useful and should shift the dial.
And likewise, that building system objective is not something which is in the New South Wales reforms. As you say, we're not quite comparing apples with apples. Now, the building system objective is explicitly not designed to give rights for civil actions in the same way as the statutory duty is. But I think it's fair to say also that now that there's the 5-year review going on with the statutory duty of care, there's been an enormous amount of litigation around every aspect of it, and some of the outcomes of that have been a bit surprising, I think, to everybody, including the High Court's decision in Packburn about proportionate liability and its interaction there as well. So yes, I likewise don't know why the decision's been made, at least for now, not to go ahead with the statutory duty. But yeah, my sense is the same as yours, Bronwyn, that it was a moment in time when there needed to be a response to the lack of a duty of care coming out of that Brookfield case in 2014.
Yeah, it'll be interesting to see what happens. It feels like we mentioned a couple of the things that Victoria has done in terms of the developer bond. We've got a 2% developer bond scheme that consumers can access if after a sort of inspection regime is undergone, there are still defects that need to be rectified. We've got the expansion of rectification powers, allowing the new commission to issue rectification orders both during and after completion of the works, and also incomplete building works as well. So it's been spoken about as a sort of expansion of the toolkit that's available to the commission to address these kind of issues. Do you think these go far enough to change the underlying behaviours?
Well, they're extensive, and we have to wait and see again how they're used. In fact, they could become a rod for the BPC's back, because owners can request that they be issued, and owners can appeal if the BPC decides not to issue a rectification order. So they're not just going to be dealing with orders issued to builders and any resistance they might get from builders. They're also going to have, I'm sure, some quite emphatic owners who want them to use these powers to intervene in their disputes in a way that has not been seen in the past. So this is significant. There is a whole bunch of new other powers coming up behind these in the legislation that has the building system objective in it. I'm not really sure why they were necessary, given we haven't even started using the rectification order power, but nevertheless, government has given a whole new swag of powers to the BPC to complement this rectification order power, including civil penalty powers and improvement notices and all sorts of tricks to put in a toolbox. So I don't think the BPC will be wanting in terms of any options. I think the real issue is going to be how do they manage the expectations of stakeholders across the board, because they've now been put square in the centre of these building disputes that are numerous and complex as being the key body that's going to resolve them. So in some ways you might say, well, is that really what we want our regulator to be doing? You know, would a New South Wales approach have been better to actually bolster people's private rights and allow them to go away and litigate amongst each other? Whereas in Victoria, we're really throwing the BPC in the middle of all of this and saying, fix it up, sort it out, tell everyone what to do. And that potentially will have the BPC in court with their decisions being challenged by all sorts of different stakeholders. And that's going to be another sort of version of costly system trying to work through those rights that people now will see that they have against the regulator. So it'll be very interesting to watch.
Yeah, absolutely. It's something that we spoke about, the Queensland experience, something that happens with the Commission in Queensland, regularly having its decisions reviewed by homeowners that aren't happy with its decisions. So, yeah, we'll certainly see a lot more of that.
So Exactly. I mean, as you say, Bronwyn, there's now so many different arrows in the BPC's quiver. The big issue is going to be how they use those arrows and indeed whether people know about them. But yeah, many of them are very, very onerous potentially. And so any time there are very onerous powers, there's always a risk that a regulator might stay their hand, if I can keep going with that quiver analogy, because they're worried, as you say, Bronwyn, that there might be significant court challenges to that. And we do see that every time there's a new change to the regulatory system. But at the same time, there's a real risk that people just won't know about them. And we all know that ignorance of the law is no excuse. But when these laws are so complex, there's a massive, massive job for the BPC and all of the industry bodies to make sure that people are across the detail of them. Otherwise, we just can't expect them to work.
So turning now to some of the industry criticisms of these reforms, there have been some concerns about the costs associated with reforms, uncertainty, project delays, and, the potential effect on housing supply as well. Are these criticisms fair, Bronwyn?
Are they fair? I think they're probably to be expected. There's a lot of change coming, and as we've said a couple of times, the way in which this is implemented is going to turn on people's impressions of how successful it's been. So I can see why the building industry is a little bit worried that they might be treated unfairly, and they're probably the ones who are most reluctant about these changes and what it is they're going to be ordered to do and whether that's going to be fair and reasonable. And, for example, if a builder is ordered to do something that they believe is related to a design defect, then how does the designer take accountability for their part in a defect or some other party? So I think there's a lot of unknowns, which of course makes people nervous. And absolutely, MBA and HIA should be challenging these things on behalf of their members to make sure that there's a level of fairness in here. So I don't think it's been unusual or unfair in terms of those concerns, but we all have to wait and see how it rolls out. And I'm sure there'll be teething problems and plenty of people ready, very quick to criticise some of the early cases that will come out of these new powers being used.
That's right. And I guess from an academic point of view, it is, again, one of those areas where we're so grateful, Bronwyn, when you or other people do some serious empirical work in this area, because it's such a complex area to try and work out cause and effect. I guess the major signifier of success in this area will be if there's not another catastrophe like the Grenfell Tower fire, which we've just had the 9th anniversary of, or the Wang Fuk fire in Hong Kong last year. Those types of things are catastrophic and by their nature will drive the sorts of regulatory reforms that we're seeing now. But the more granular aspect, which is again what your report for the VBA gets into, is the endemic level of defects that all of us are living with day in, day out, whether we're tenants, residents or owners of buildings, and for that matter, builders themselves, and the levels of stress and anxiety that they face in having to deal with those issues as well and pick up the pieces when another builder has done the wrong thing, for example. So measuring success in those outcomes is difficult. But at the end of the day, I think that the BPC and these reforms have nailed their colours to the mast in terms of consumer protection and privileging consumer outcomes above other interests in the area, which then means that that is something which hopefully can be measured through satisfaction surveys and so forth. So there's real potential for more empirical work here. Of course, as an academic and researcher, I'm going to say that I really appreciate the way in which the regulator over the years has funded this sort of research, but that sort of thing is absolutely vital.
Absolutely. I think if we can end the discussion maybe talking about, is there anything that you would have liked to have seen in the reforms that didn't make it into it to strengthen or add to the consumer protection mechanisms? Bronwyn, if I can start with you.
Well, I guess the statutory duty of care is something that's missing. I can't think of any good reason why it shouldn't have been included as an adjunct to these changes. The other area which has been improved a little bit in the recent bill that came in is around director liability or accountability beyond insolvency, which is an ongoing issue in the industry. How do we tackle that? So there is some work around that now, and in fact there is an ability to pursue directors. But the other thing really is, what's the role of the developer? So we've got the ACT government introduced developer licensing, first jurisdiction to do so, and I was heavily involved in that reform work. It wasn't my idea. It was something that the government had announced long before I was engaged by that government to help them sort of sort through what that could look like. But I do think that governments need to ensure that we have accountability at the developer level. They have an enormous influence over the project, and they're generally special purpose vehicles, and so they can fold up and go away right when their liabilities start to increase on a project. So I feel like there's still some stuff in that space that hasn't been done as well as it could have been in Victoria. They've hovered around it with the developer bond and other things like that, but they've just fallen short, in my view, of really sending a clear message that developers are part of this network and have to be one of the primary practitioners responsible when things go wrong. And I just don't think we quite got there.
I agree, Bronwyn, about the statutory duty. I think there was an opportunity to codify it in a balanced way. So my own view about that is the Canadian approach out of the Winnipeg condominium case many years ago is probably getting the balance right, in that it requires a duty of care where there is something which is going to be dangerous down the track. In other words, it requires that get fixed before it actually then crystallises in something that hurts people. Of course, what I'm going to say, consistent with things I've been saying for a long time now, is gosh, it'd be great if these were actually national reforms and we could have a workable building ministers meeting or whatever it is, maybe the federal government take over in this area, because there are so many different pieces to this jigsaw puzzle at not just state level, but also at local level and at federal level as well. And then we've got all of the overlays in what is not just a national industry, but an international industry as well. And we've got people moving not just around the country all the time, not just around the city, but around the world to work on these sorts of projects as well. And you do need to have at least a harmonised approach across the country in order to make sure that we maximise the chances of people actually knowing about these types of things.
That's a really great point, Matt, especially with modern methods of construction and all that the governments want to do to increase the rate of housing supply through those off-site construction methods. What it's showing is these problems that come with a lack of harmony across jurisdictions, because when you want to try and do something federally, things just don't fit together. You can't do things quickly. And, so I think we need the federal government much more involved in building regulation in a much more meaningful way. If we're sort of talking about building regulation across the country, it really needs to come from federal government, including, to start with, setting up a federal agency. And we've got the Australian Building Codes Board that's been there now for 3 decades. It's not a statutory body. It doesn't have powers. We need a Commonwealth statutory body that has powers and a coordinating role between the states and territories. There's so much that needs to be done in that space. So well done to Victoria, but this is a national issue that needs urgent attention.
Absolutely. National harmonisation is certainly the dream. That could be a podcast episode all in and of itself. So I think we'll end the discussion here. And thank you, Bronwyn and Matthew, for joining me today.
Thank you.
Thanks so much.
Thanks for listening to Building Tomorrow, the Society of Construction Law Australia podcast.
The Society of Construction Law Australia is a national organisation of members at all stages of their professional career with a shared interest in construction law.
For more info about the Society of Construction Law Australia, head to the website scl.org.au. This show was produced with strategy and production support from Sound Cartel.
To make sure you don't miss an episode of Building Tomorrow, be sure to subscribe to or follow the show in your podcast app.
And while you're there, leave us a 5-star review. It really helps others find the show. I'm Bronwyn and Matthew.
I'm Bijal Amsal.
And I'm Jennifer Raphael. And we'll see you in the next episode of Building Tomorrow.